Hello, everybody. Welcome to Chatting with Charlie, EB-5 Investor Outlook. My name is Joey Barnett. I am a partner at WR Immigration. I am an EB-5 attorney, and I am joined today, of course, with Mr. Charlie Oppenheim, who used to work for the State Department, drafting the Visa Bulletin for many years. And we are very happy to have you here today. Whether you are coming in live during our webinar or whether you are listening in on YouTube, we thank you for joining us. We have a lot of great information to share. And with Charlie's expertise, we have a lot of insights that, frankly, nobody else in the world has. So we are very, very fortunate to have Charlie with us today, December 13th, 2023. And I wish you all happy holidays. As always, this webinar does not constitute legal advice. It's for informational purposes only, but we want to speak with you. We want to help. We have a great EB-5 team. We are filing a lot of cases, I-526E cases for folks inside the United States and outside of the United States. We're working with regional centers and developers to file I-956Fs. There's been a huge pickup in the processing of those applications recently, and we're really seeing EB-5 pick up in these last few months. It's wonderful to see, and we hope it continues indefinitely. Our EB-5 Investor Outlook is just one of the Chatting with Charlies that WR Immigration puts forward. Charlie's doing another webinar next month talking about predictions and outlooks for EB-1, 2, and 3. And I invite you all to speak on those. It's in particular because of the January Visa Bulletin, which advanced a fair amount. There's been a lot of movement, and Charlie is going to be providing his insight next week, Tuesday, I believe. Is that right, Charlie?
Yes.
Exactly. So please register for that. You can do that on our website. We have our chat and our question and answer feature available. So if you have questions or want to comment on something that we're talking about, feel free to put that in, and we'll try to answer it either during the course of the webinar or at the end. And we're really ready to get going here. WR Immigration, we are one of the top U.S. immigration law firms in the United States. We have 9 offices. We have over 150 staff members, I think over 40 attorneys. And our EB-5 practice is based in Los Angeles. That's where I am. And we have 2 of the 2023 top 25 immigration attorneys, myself included, and my partner, Vivian Zhu. And next month, the EB-5 Investor Magazine, which gives these awards out, and they're voted by peers, they're doing a webinar in Newport Beach, January 15th and 16th. And so we invite you to register and sign up and come meet us at the conference. All right, let's get into it. Oh, and I guess my last comment here before we move forward is, Charlie, this is our 10th EB-5 Investor Outlook in 2023. Just as our firm is to journey forward, it's been an honor to journey forward with you here on these webinars. And so it's been great to get to know you a bit more and to do this together. So thank you so much.
It's a pleasure. It's great staying involved with the EB-5 program.
All right, so this is our roadmap for today's webinar. First, we're going to be talking just basics about EB-5 and why the window of opportunity to do EB-5 is right now. I can't say that enough. Do not delay. If you want to do EB-5, the time to do it is now. And what does that mean? That means working with an immigration attorney to strategize regarding source of funds and getting those documents in order. And then working and doing your due diligence and speaking with regional centers, evaluating EB-5 projects from both an immigration and from an investment point of view so that you can meet both of your goals. You want to get the green card and you want to get the return of your capital at an appropriate time. So those are very general statements to very in-depth actions. And I would be happy to speak with anybody who is interested in doing EB-5 or learning more about the program. And hopefully you'll get some little bit understanding from this webinar as well. And we're going to be talking about the January 2024 Visa Bulletin. There's been some advancement. We'll get some insight from Charlie on why that happened. Then we're going to be speaking about some I-526E data that was obtained by the American Immigrant Investor Alliance through a FOIA litigation because USCIS has to date refused to provide this on a timely basis. And there's some information that we have from there that's very interesting. It's also a bit outdated and potentially not something that should be relied on, and we're going to go through that. And then finally, we're going to spend a bit of time talking about EB-5 visa allocation and what needs to happen to ensure that the U.S. government, USCIS, and the Department of State is actually effectuating Congress's intent to issue these reserve visas that were created with the EB-5 Reform and Integrity Act. And we are now starting to see I-526E approvals for those reserved categories, both in rural and in high unemployment. And so now the onus is on the State Department to schedule those interviews, to interview the applicants, and to issue the visas so that those numbers can be used and not wasted in the future. So first, let's talk about EB-5 and the new EB-5 law that was passed in March of 2022. The minimum investment amount was increased from $500,000 to $800,000 for investments in projects that are located in rural or high unemployment areas. Otherwise, the minimum investment is $1,050,000. And no matter what project you choose, no matter whether it is rural or high unemployment or unreserved at that $1,050,000 level, you need to document your source of funds to the U.S. government. And I cannot stress how important this is, in particular because the requirements appear to be getting more and more stringent, in particular with regards to transferring money out of countries into the United States and making sure that it is abiding by local laws. EB-5 is a job creation program, and you have to show that your investment is going to create 10 new full-time jobs. And you only get the immigration benefit if those jobs are actually created and if you can document sufficiently your lawful source of funds. And so you work with an immigration attorney who is experienced in EB-5 to prepare a legal brief and to compile and document and explain to USCIS officers that this money was lawfully obtained. The government will act like a forensic accountant. They want to see tax returns. They want to see bank statements. They want to see real estate sales documents, depending on the source of funds. It is very, very complex and detailed, and you need an experienced EB-5 attorney to help you there. This is not a place where you want to go to any immigration attorney because EB-5 is specialized, and there are specific things that we know USCIS wants to see. And if you don't submit them, you can expect a request for evidence, and you'll only have 87 days to prepare and submit that back in order to get your case approved. So we are very conservative at WR Immigration. We make sure that we get all of those documents up front. There is a fair amount of back and forth, but we try to make it as simple as possible by providing detailed checklists, by reviewing those documents very carefully, and ensuring that we have what we need to file an approvable case. One common question that I get all of the time is, well, what's the difference between a regional center EB-5 and direct EB-5? And there's two big differences. Number one, it has to do with how you count jobs. With a regional center investment, you are able to count indirect and induced jobs, as well as direct jobs that are created through either construction expenditures or through operational revenue. So let me give an example. Let's say you're investing in a project that is building a new apartment building. Money that is being used on the construction of that building for the general contractor, for the subcontractors, for all the materials, for all the fixtures, all of the money that is spent for that activity to happen is creating jobs. You're injecting money into the economy. And when you go through a regional center, you're able to use these economic models that demonstrate job creation just based on construction expenditures. Then, once the building is up and they're leasing it out to tenants and the company is getting lease payments in, there are more jobs that can be counted based on the operational revenue that comes in. So as the leasing occurs and as tenants come in, they pay their monthly rents, and that also can be used to project job creation. So that's, I think, the biggest difference. Whereas with direct EB-5, you need W-2 workers on payroll in the company that you have invested in or in its wholly owned subsidiary. The other big difference between the two is that you're really much more actively involved in doing a direct EB-5 case than you are with a regional center, where you are more of a passive investor and you invest into a fund. That fund is generally managed by a manager or a general partner. And the purpose of that fund is to pool investment from multiple EB-5 investors and to provide that as financing to a U.S. company. A lot of times it's a real estate development because you can count those construction jobs based on expenditures. And from my point of view, you can mitigate the immigration risk in EB-5 by going into a regional center project where the jobs are in the process of being created or potentially have already been created. Whereas if you do a direct EB-5, you have to create these new jobs. And if the business doesn't go as well, or if there's delays or the economy turns poor, that can impact the business, that can impact the ability to create the jobs, and that impacts your immigration status. When folks come to me who are entrepreneurial and they are saying, well, we want to do direct, I always say, you got to at least look into regional center. And depending on how much capital you have, it may be worthwhile to do a regional center project, get your EAD in 4 to 6 months, and then start your company on that without the EB-5 rules hanging over your head, telling you how to run your business and how many jobs to create. And so we do direct EB-5 cases. I'm the attorney at WR Immigration that files those, and we do file those. But in general, I would say over 90% of people who do EB-5 go the regional center route. The EB-5 Reform Act of 2022 created these new reserve visa categories. Charlie, this might be a good place for me to ask you just a bit about that. Can you tell us about those visa categories and what it did with regards to allocation of visa numbers?
Sure. The employment fifth preference gets 7.1% of the overall worldwide employment limit. And with these three new reserved, there's a carve out. The 20% high unemployment, 10% of the overall limit, and infrastructure only gets 2%. And the unique thing here is those reserve numbers are carried over. Any unused numbers from, for example, fiscal 2023, any numbers that were unused are added to the 2024 limit. It's a one-time carryover. This is unique to the EB-5 program, and it does not happen with any of the other family or employment categories. So this was a very beneficial thing with the enactment of this bill.
And we have a great chart later in the presentation, which sort of highlights how those carryovers have occurred in the past couple of years since the enactment of the Reform Act. And that's information and data that I don't think anybody has presented yet. So if you're here and you're listening, stay tuned. You know, a lot of questions get asked. Well, can I qualify for EB-5? You know, who is eligible? And really, what's different about EB-5 is that your green card is based on investment of lawfully obtained capital and the creation of U.S. jobs. There is no skills requirement. There is no language requirement. There's no educational requirement. It can be from individual in any country. We have clients from tens, if not hundreds, of different countries around the world. And you can be in the United States. You can be outside of the United States. The source of funds for the EB-5 investment can come from multiple sources. They can be gifted. You can get a loan. And so we have students who are in the United States who are thinking about their immigration future, who may not be selected in H-1B lotteries, and they get gifts or loans from their parents in order to do EB-5 and to remain in the U.S. without having to worry about employer sponsorship. There's a lot of flexibility with EB-5 because you can work for yourself, you can work for any employer, or you don't have to work at all. And so that is a big benefit to EB-5. Another huge group of folks who are looking into EB-5 right now are Chinese and Indian nationals who are backlogged in the EB-2 and EB-3 categories. They look at their priority date. They look at the final action date in the Visa Bulletin. They see the very slow movement, and they want to be more proactive in their immigration journey. And they've been working in the United States. They've saved up money. They have got RSUs. They have their 401k. You know, maybe they've purchased a house and are now taking out a home equity line of credit, and they're able to fund that $800K investment and get the green card through EB-5. And, you know, folks who are outside of the United States, you can file it and then wait for a U.S. consulate to issue a visa. Or if you're in the United States and you lawfully enter, then there's the possibility of doing an adjustment of status where you wait for the green card in the United States during the time in which your EB-5 petition is pending. And so this is called the concurrent adjustment of status. And what's great about this is that when you file that adjustment of status application, you're also able to file for a work authorization and for travel authorization. And we are getting these in as quick as 3 months, and they're good for 5 years. So you come in, or you're here on an H-1B, you file your EB-5 case, at the same time you file your adjustment of status, and at the same time you file for the work and travel authorization. That would allow you to remain into the United States until they make a decision on your adjustment of status. They won't make a decision on your adjustment of status until the underlying basis, the EB-5 petition, has been adjudicated. But in the meantime, you have the right to work and you would have the right to travel internationally. We're going to be talking a bit about the imposition of final action dates for these reserved visa categories. And when that happens, those who have pending I-526s or even approved I-526s and their adjustment of status remains pending, nothing happens to that adjustment of status. Those people are able to remain in the United States lawfully until the Visa Bulletin shows that their priority date is current. And so this new EB-5 law really opened up a lot of opportunities. But as we're going to explain in just a moment, the time to do it is now, because there are waiting lines forming already. We may not be able to see that in the Visa Bulletin, but we know based on what our firm is doing, what we're talking about with others in the industry, and this FOIA data that we got, well, that AIIA got through a FOIA, shows that there are these backlogs forming. And Charlie, for EB2 and EB3, you get your priority date one way. How do you get your priority date for EB5?
The filing date of the petition, and you want to get this status as quickly as possible. So as you said, because you always want to be as close to the front of any line which may potentially develop, and these lines will be developing in the future.
Yeah, and because of that, sometimes capital isn't liquid. And so what some folks are doing is they are doing partial investments. That's very in vogue right now in EB-5, but the concept isn't new. And that's where you make a partial payment, say 500,000 of the 800,000 investment, to file your case, to get your earlier priority date, and then you make the balance of the payment within 6 months or 12 months. And we've gotten approvals that way. It is allowed under EB-5 law, but there are USCIS policies that are sort of vague. And so you want to work with an immigration attorney to make sure that you are doing that the right way. Another great benefit of EB-5 Reform Act is this INA 245K protection. Previously, if you were out of status for 1 day or had 1 day of unauthorized work, you were not eligible to do adjustment of status. Now with this 245K protection, you can be out of status for up to 180 days or working without authorization for up to 180 days and still be eligible to file for an adjustment of status application. This is important for folks who are on H-1B or F1, maybe they've been laid off, and they have their 60-day grace period, and that has passed. They haven't been able to find someone else to work, and they want to remain here. Well, this 245K allows them to do that even past that grace period. So a lot of good stuff for EB-5 right now. We're seeing a lot of activity, and we would be happy to help anybody who's interested. We do free consultations, and we want to be here as a resource for immigrant investors. All right, now we're going to get into the nitty-gritty a little bit more. This here is from the January 2024 Visa Bulletin. First, we're going to talk about Chart A, the final action dates. And there are the 4 Visa EB-5 categories, the 3 reserved or set-aside categories, all of which remain current, and then the unreserved category. Those are immigrant investors who filed before the EB-5 Reform Act, as well as those who file at the 1,050,000 level. And there was some great movement in the Visa Bulletin this month. For China, it moved about 9 weeks from October 1st, 2015 to December 8th, 2015. And for India, it moved just about 2 years from December 15th, 2018 to December 1st, 2020. So, Charlie, my first question to you is, let's talk about India unreserved first. Why do you think the Department of State was able to advance it so much?
I think that based on the amount of numbers that were used by India in the unreserved categories last year in relation to their pending demand at the National Visa Center, I think basically they're running out of demand. And by advancing the final action date to December 1st of 2020, they're kind of opening up, casting the net wider, trying to capture more applicants that can potentially use numbers versus the amount available for Indian applicants. So again, they were running out of demand. They had to advance it by the 2 years in order to generate more eligible demand to maximize number use under the India annual limit for this year. And which is a very good thing that they're advancing it early in the year. This will allow Indian applicants that may be in the U.S. to have their adjustment of status cases started on processing earlier, and those applicants who are processing at overseas post to potentially be processed in the coming months.
That's a very good point, because I would say, or at least guess, estimate that the majority of the unreserved cases filed by Indian nationals really happened in 2019. That was right before the EB-5 program was set to sunset in November of 2019. And so, like Charlie said, they are casting this net open. If you have an I-526 approved pre-RIA, you're pretty much able to move forward with the next step of the visa with the green card. The real issue, I think, is that USCIS still has a fairly large number of Indian I-526 cases that were filed in November of 2019 to get adjudicated. And when those get adjudicated, then more demand will be or I guess there'll be more visibility for demand at that time. Right, Charlie?
Yeah, and that's why applicants need to, whenever they're eligible for processing, they need to proceed to with their case as quickly as possible. Because the fact that the date is now December 1st of 2020, as you say, if there were a significant amount of demand with earlier dates, it is possible that state may need to make corrective action in that date later in the fiscal year. So again, act quickly when you have access to your case and can be proceeding.
And let's just not beat around the bush. When they say take corrective action, you mean there'll be retrogression potentially?
There would be a potential retrogression, yes. Again, as I say, they've made this large movement in order to generate demand in the coming months based on their anticipated need. And if that need is if the actual demand coming in exceeds their estimated need, then they may have to retrogress the date later in the fiscal year.
And so if that were to happen, and there was a retrogression, but you have started this process of moving forward, and the fee bill is issued, and you pay it, and then you work to complete the DS-260. What does that mean if it retrogresses and your priority date is no longer current?
These dates that are listed here represent visa availability strictly in January of 2024. So my case could be being processed now. I'm within that date, but my case cannot be finalized until August. I am subject to the August date that is listed in the August Visa Bulletin, not what is listed in this one now when I filed. So again, it is whatever the applicable final action date is for the month in which your case has potential final action. So again, this is why you need to act in a very timely manner when your case becomes eligible, as it may be at this point.
And what are your thoughts about the movement of the China unreserved final action date by over 2 months?
This is a very positive event. This is actually recovering and covering ground that had been, achieved by the final action date in earlier years. So my hope would be that for February and beyond, that we may see more forward movement of the China unreserved date at maybe a greater pace, or equal at least. Again, to try to maximize number use under the amount that are estimated to be available for China in fiscal 2024. But for both China and India, these movements are very good signs.
Okay, great. We got a question from Ed Bashara. Thanks, Ed, for listening in. He's asking, is the reserved category only available for investors who file after the RIA was enacted in March of 2022? And the answer is yes at this point. Those reserve visas are only allowed for post-RIA investors. Now, there is some interesting stuff happening with I-526E approval notices, where they have a dual approval notice, and it's possible that those who invest in reserved visa categories may be able to get an unreserved visa number. And in my mind, that would make sense for sort of rest of world applicants, non-Chinese, non-Indian, where it is current. And the rationale there would be to maximize visa number use, allow China and India, which is backlogged in the unreserved, to have as many numbers as possible in the reserved categories. And you would do that by allowing the unreserved visa numbers go to the rest of world reserved visa applicants. Oh man, that was a mouthful. I hope that made sense. Charlie, your thoughts on that?
Yeah, I think that you're absolutely right. It is more advantageous, I believe, for rest of world applicants, those other than China, India, to be processed in the unreserved category, because the annual limit is much higher for the unreserved. They're going to get 68% of the annual limit versus the other three categories being divided, plus the per country limit for the unreserved category, because of the higher overall limit, will also be higher. So I think it is a win-win for rest of world applicants to be processed as unreserved. And as you mentioned, if that were to happen, that will provide more availability of numbers for Chinese and Indian applicants in the reserved categories.
You mentioned the per country cap, and that's really important. And DOS has kind of modified its interpretation this year. But my first question to you, I have a sort of a series of questions here, Charlie, that I'd like your thoughts on. Does the per country cap apply to reserved in general, the full 32%, or does it apply to each reserved category?
It would be each of the reserved categories, and it would be the per country limits are 7% of the overall applicable annual limit.
So does that mean, though, that for countries where there is a lot of demand, like China and India, would they only get 7% of those visa numbers in those reserve categories?
No. Just as an example, say the annual limit in the rural reserve, 5,000 or 2,000 numbers. And just for easy math, say that China and India, their per country limit was 300. So that what state would do is subtract those 300. So there would be 1,400 numbers available for the quote rest of world applicants, because both China and India could be expected to use their 300. Then state would say, well, the rest of the world only needs 600 of those 1,400 numbers. So the remaining balance of 800 would be made available to Chinese and Indian applicants in priority date order. So there was always the availability of otherwise unused numbers. They can be made available to those countries which have hit their annual limit.
And that's what's happened for unreserved in the past, right? For
Yes,
Chinese.
it typically China number use has typically been a minimum of 40% of the EB-5 numbers because of this availability of otherwise unused numbers. In the very early days of the program, China was probably using 75 or 80% of the numbers because there just wasn't enough rest of world demand, and there was significant amounts of otherwise unused numbers.
But can you explain why those otherwise unused numbers, they're not just going to be going to Chinese now for these reserve visa categories, right?
No, the otherwise unused numbers are made available strictly in priority date order. In the old day, pre-RIA, the Chinese applicants typically had the very earliest priority dates. That is why they use the vast majority of the numbers. In these new 3 set-aside categories, the mix of applicants from all over the world is likely to be much greater. So the otherwise number used potentially could be spread out much wider.
Hey, thank you. So let's talk about Chart B. Chart B has pretty much remained the same as it was last month. But actually, did USCIS say that they would allow Chart B for adjustment of status filings next month? I don't know if I checked that, to be honest. But if they do, and I believe they probably will, just based on visa usage at this point, if your priority date is before the Chart B date, then you would be able to file for an adjustment of status if you were eligible to do so in the United States. And like I said before, we're getting EAD and travel authorization approvals in as quickly as 3 months. I just got one last week for a family, and it was good for 5 years. That should be more than sufficient amount of time for USCIS to adjudicate their I-526E and their adjustment of status. And now they are able to work without any restrictions in the United States until they get their conditional green card. And then that work freedom continues at that point. All right. So this
Joey,
yes.
Excuse me, Joey.
Yes.
While you were talking, I just called it up. The USCIS says for all employment-based preference categories, you must use the dates for filing chart in the Department of State Visa Bulletin number or January 2024. So they are allowing the Chart B dates to be used. I would strongly suggest people file while Chart B is available. Often between January and March, they stop using the Chart B and only apply Chart A. So again, act in a very timely manner for your filing.
We got a couple of questions here that talked about kind of what we were saying before with the dual approvals. This is from Carol Vanderway. Hi, Carol. Thanks for listening in. Can an investor be adjudicated in the unreserved category if they invest in a rural or high unemployment category? So when I think what he is saying is when he says can be adjudicated, I think it means can be given a unreserved visa number. And that is what appears to be possible based on those dual approval notices, visa category in the approval notices. We have a client for an approved I-526, an Indian national outside of the United States in the unreserved category who filed in July 2019, can the next stage be filed? Well, the answer is yes. Yes, you can, because their priority date is now current, come January 2024. Okay. So this next slide here is the data that we got from the American Immigrant Investor Alliance through their FOIA litigation. Thank you so much, AIIA, for letting us use this data and for fighting the good fight to get it when USCIS hasn't provided it publicly yet. And Charlie and I and a couple of others did a webinar last month with AIIA. And if you're interested in learning more about that, we really get in depth where we talk about the supply and the demand and what it may mean for visa wait times and things like that. I recommend that you go on YouTube and look it up. But this here shows the total I-526 or I-526E receipts. So how many cases have been filed by immigrant investors from April of 2022 through April of 2023. Couple of things about this. So first of all, you can see that there has been more during this time period. There was more high unemployment cases filed than rural cases. You can see that there were more Chinese cases filed than any other country. And you can see that there really wasn't too much of a crazy pickup once we got to September of 2022. You know, it's not like there was like an exponential growth of filings for those next 8 months. That's all I'm really reading into this. There has been a lot of activity in EB-5 over the course of the past 8 months, and we don't have that data. And so honestly, I'm not really looking at this too much when advising investors on the decision, hey, should I go rural? Should I go high unemployment? It's just, I think it's just limited data, and it doesn't tell the full story. It doesn't tell us how many cases have been filed by Chinese or by Indians in either rural or high unemployment during these last 8 months. And, you know, there were a lot more high unemployment projects in the market a year ago than there are today. There's also more I-956F approvals today than there was a year ago. And because of that, that is impacting investors' investment decisions. The I-956F is the project approval application that is filed by the regional center. USCIS will allow an investor to file their I-526 after the 956F is approved, but they won't approve the I-526 until the 956F is approved. So finding a project with an approved I-956F is important because it shows that USCIS has reviewed the documents, they agree with the TEA analysis, they agree with the job creation analysis, they agree that the project documents and offering documents all comply with EB-5 rules. And based on what we're seeing in practice, it likely means that your case is going to be adjudicated a bit quicker than if they had just filed the I-956 a month ago. Because there is this process flow by USCIS when adjudicating EB-5 cases. Charlie, when you look at this data, can you make any sort of estimates or guesstimates about when a final action date may be imposed for rural?
Sure. Excuse me. Based on this, I don't believe everything shall remain current in both rural or all the reserved categories throughout fiscal 2024. I think it is very likely that a final action date will need to be imposed for both rural and high unemployment at some point during fiscal 2025. And I believe for the rural, in a worst case scenario, whenever a final action date is imposed in fiscal 2025, it would be a worst case scenario, a spring of 2023 or later final action date. And for high unemployment, based on looking at this data, I think a worst case scenario when a final action date would be imposed is very early of 2023.
Okay, so what that means is that for the next 8-9 months, at the very least, maybe 12 months, we're going to see the Visa Bulletin show current for the reserve visa categories. And after that, there will likely be some final action dates imposed, which would prevent folks from moving forward with the green card process. That is why I am saying that the opportunity is now. You want to file now and potentially even get your I-526 approved in the next 6 to 8 months with these prioritized processing, so that they can start taking action potentially on your adjustment of status, or so that you can move forward with immigrant visa processing before there is this imposition. Now, let me ask you this though, Charlie, because this is something that I get asked all the time. It's like, well, what's the wait time? Can you tell me how long it will be until I have a green card? Why is it difficult to estimate that based on this limited data?
There are so many variables involved. It is, you really cannot, at this point, with the limited amount of information that's available, it is really not practical to try to say how long somebody's wait time will be based on the limited amount of data. But this data does kind of indicate that, like I said, that at some point in fiscal 2025, it is likely that final action dates would need to be imposed, in large part because by then, number use in both the rural and high unemployment areas should be beginning, and the annual limits are likely to be lower than they are now. So that the combination of lower limits and increased number use will require the final action dates. But again, the beauty of this is, with everything staying current throughout the remainder of this year, and likely in the early part, at least, of fiscal 2025, as you said, it allows people to be filing, especially those doing concurrent filing. And again, you always want to get as close to the front of any line that develops, so you can be processed when the line does come to fruition and a final action date is imposed. But again, I think at this point we need more data, and we need to say we don't really have information on how quickly these petitions are being approved, when they will result in cases actually being scheduled for adjustment of status or potential visa issuance at overseas post. We don't have information on the refusal, the denial, or approval rates. So there's so much information that we need to make predictions at this point.
Got it. Yeah, I agree. I think it's a little bit, I don't want to, I'm not say irresponsible, but it's not going to be accurate. And so I think folks who are looking for timelines, it's really, really tough to say. And what I say is you need to get your spot in line, and you do that by filing the I-526.
Right. And one of the other things is, in an ideal world, numbers would start being used in these two categories this fiscal year, hopefully by the summertime, because every visa that is used this year is one less that needs to be used in the future. And that could drastically impact the need for final action dates to be imposed, or what those dates would be if large amounts of numbers are able to be used this year when there are more numbers available.
And we're going to get to that in the next slide. Well, in 2 slides, but the next one, oh wait, yeah. I want to go to this one first. Charlie, you created this slide based on the data that AIA got, and it's only based on the filings up through April of 2023. So, but what does this show?
Well, this clearly shows, and again, it's important to remember this is only through April of 2023, but it shows that the amount of rural petitions which have been filed, and assuming 2.5 applicants per case, that there's only 1,090 applicants competing for the amount available to them. So there's 5,000 numbers available, only 1,000 applicants. Therefore, there is no need for a final action date. In the high unemployment area, there's potentially 2,700 applicants with petitions filed and only 2,500 numbers available under this year's limit. Again, numbers are not going to be processed this year in demand in levels which will require dates to be imposed. Therefore, everything will remain current. But this shows that in the future, in 2025, that's why I'm saying it's likely that final action dates will need to be imposed.
Okay. You heard it here, folks.
And one other thing, the information that was provided based on the FOIA request, and I applaud their efforts in getting that information, requesting it, and being provided. It would be in an ideal world, the Immigration Service would publish this information so there would be transparency and practitioners could look at the data without the need to submit a FOIA request. And this information in the format was provided is available on a monthly basis. So if they provide it on a monthly basis, a quarterly basis, it would be very beneficial to the industry and allow people to make more reasonable estimates and not having to be speculating as much. But again, this type of information is available if the Immigration Service chose to provide it on a regular basis.
So Immigrant Investor Program Office, if you're listening, maybe you are, I don't know, please just give us access to that data. You're already collecting it. It can't be too difficult to provide it to the public. Otherwise, we're always going to be behind, right? We don't have up-to-date data, which means we can't properly advise clients on wait times and things like that.
True, and it would reduce their workload from other groups submitting FOIA requests for the data because there would be no need for it.
Right. All right. So this next chart is something that we've shown a type of this before, but we've expanded it, and it really kind of shows a holistic use of EB-5 visa allocation and use since fiscal year 2018 and what could potentially happen up next fiscal year, which is 2025. So there's a lot on this, and what I want to start with is the fiscal year 2022. You see the green boxes, the 6,396. Those were the reserved visa numbers. None of those were used in that fiscal year. So as Charlie mentioned at the beginning, those carried over to reserved in the next fiscal year, last fiscal year. Well, last fiscal year, they weren't used either. And so now they are carried over to the unreserved. And when you add up that 6,396 number with this new unreserved 68%, which is the 7,773, that's where we get this unreserved total for this fiscal year of 14,169. That's the total number of unreserved visas that can be issued to EB-5 applicants in this fiscal year. The fiscal year goes from October 1st to September 30th. That's the government's fiscal year, and that's how the Department of State does these allocations. Charlie, can you explain this first column on the worldwide level and what it normally is at and why it went so far up and now it's coming back down?
Sure. The employment limit, each year's annual limit is a minimum of 140,000. And to that, you add any unused family-sponsored numbers, which remain unused from the previous fiscal year. So we saw during the COVID times, the State Department typically uses approximately 95% of the family-sponsored numbers. During COVID times, most of the overseas posts were closed or had severely diminished processing ability. Therefore, there were record high amounts of unused family numbers being added to the employment limits. So you will see that in fiscal 2022, the annual limit was 281,000, which is double the minimum number limit. Again, it was high in 2023. It's starting to return to more normal levels this year at 161,000. But these numbers for the limits from 21 through 2023 are artificially high, again, returning to the more normal limits. And I believe by fiscal 2025, the worldwide employment limit is going to be in the 145,000 to maybe 150,000 range, meaning the employment fifth preference limits will be reduced from what they have been in the previous several years.
Now, we know how many EB-5 numbers were used in fiscal year 2022. That's the 10,885. They were all the unreserved visa numbers. And there was a smaller number of EB-5 numbers that were not used by EB-5 applicants that fell up to EB-1 and then down to EB-2 and 3. Charlie, do you have any idea of how many EB-5 numbers were used in fiscal year 2023?
I believe all of the available EB-5 numbers were used in fiscal 2023. Hopefully that information will start to be published. If people look at when the visa office publishes the data for the fiscal 2023 in their annual report, look at table 5. That represents number use on a worldwide basis, but I believe it will show that all of the available numbers for the unreserved category in 2023 were used, which is a very good thing, helping to off some of that waiting list.
And I'm really hopeful that we have that trend continues here in fiscal year 2024. And I know the Department of State recently published some statistics about the October visa issuance at consulates abroad. And we were talking about that earlier, Charlie, and I think you had mentioned that there were under 400 unreserved visa numbers that were issued to Chinese. What does that signify to you? Or why is that an issue?
I believe that to maximize number use under this year's unreserved annual limit, I believe that China will have to be using a minimum of 600, an average minimum of 600 to maybe as many as 800 numbers a month. And for October, they only 397 Chinese EB-5 unreserved numbers were used. Again, I think China unreserved number use needs to be averaging between 600 and 800 a month in order to maximize number use this fiscal year. The other thing I noticed that was for October, the Vietnam used over 800 EB-5 unreserved numbers. I think this is a wonderful thing. Hopefully it is working off much of the Vietnam waiting list. But depending on the size of that waiting list, that amount of number use in relation to the potential Vietnam per country limit in unreserved, that may mean that Vietnam needs to be watched in the future to see if they may be approaching their per country limit for the year. But again, it will be important to see the waiting list information that the State Department will publish. Each year they publish the data, and hopefully it will be published within the next 2 to 6 weeks, and it will show the amount of EB-5 petitions on file at the National Visa Center as of November 1st of 2023. And that will, again, allow us to see, okay, they issued 800 numbers for October. How does that correspond to the amount of demand that is on file for Vietnam at the National Visa Center?
And that is peculiar because the Department of State is supposed to, like, there's like every quarter they're supposed to issue a certain, or estimate to issue a certain percentage of the total allocation, right? And that just doesn't seem like that was followed for unreserved Vietnam for the, at least the,
well, yeah. In theory, there is a 27% per quarter for the first three quarters. That's a guideline. It can be over or under, as long as, say, after 6 months you're within the 54% limit. Again, the 800 numbers that were used may represent the vast majority of the Vietnam demand. Therefore, it wouldn't matter if they had used more than the 27%. And that may be a very good thing, because Ho Chi Minh City may have indicated that they had the processing capacity in October to handle a very large amount of Vietnam EB-5 cases, and they may not have that luxury in the coming months. So that's the type of thing that could be taken into consideration. And again, it's interesting, for the month of October, only 31 Indian EB-5 numbers were used. And again, that is why I think they kind of opened up and advanced the India final action date so much, in order to allow more number use under the per country limit for the year.
do you think there will be the same level of, I'm just going to use the term visa wastage, or visas not being used by EB-5 in this fiscal year, and as we saw in fiscal year 2021 and 2020?
No, I would think that that would almost be unconscionable, given this is a record high annual limit that can address the unreserved backlog. And both the State Department and USCIS should take, or hopefully will take, full advantage of this extremely high annual limit to greatly reduce any backlog waiting list that they have, especially in the China category, which is back in the 2015. But for all countries who have old petitions on file, this would allow a large amount to be used. And I also believe, typically in the past, Guangzhou has used the vast majority of the China numbers. I believe that Guangzhou hopefully will be back to normal, quote, normal processing levels during fiscal 2024, which will allow them to maximize China unreserved number use and minimize or completely eliminate any underutilization of numbers.
So I realize I didn't realize this until just right now. We're 5 minutes past the hour, so we've been doing this now for 65 minutes. There is more that we can discuss on this chart, but I'm gonna, I guess, keep it as a cliffhanger so that you guys all come back for the January EB-5 Investor Outlook, which we're going to be doing next month. But it is very interesting to see these numbers on paper and the waterfall. And I hope this discussion here was helpful for you in order to sort of understand how these numbers are being used and how actually, for the most part, except for those COVID years, they've done a fairly good job at not wasting numbers recently. There is that fiscal year 2022 where they wasted almost 3,000 of them, and that's a big issue. But these COVID related wastages are a bit beyond anybody's control. Okay, so with that, I do want to thank you all for listening today. I've tried to answer the questions that came up as they were here. If you have any questions at this time, feel free to put them in. We will be making this recording available on YouTube. Just look up WR Immigration Chatting with Charlie, and you'll see all of our videos that we've done over the past year. Again, if anybody has questions about EB-5 or interested in discussing it with an immigration attorney, I would be happy to have the conversation with you. It should be on YouTube, I would think, by the end of the week. If not, then next week. So thank you so very much. If you have any questions or want to reach out, my email is here. It's jbarnett@wolfstorf.com. Thank you so very much for listening in. Happy holidays, happy new year, and we will talk to you again in 2024.